This is a brief discussion of double sale under the law on sales. What is a double sale? Double sale is the sale of one and the same property by the same seller to two or more buyers with conflicting interests. For there to be double sale, the following requisites must concur. 1. There are two or more transactions which must constitute valid sales. 2. They must pertain exactly to the same object or subject matter. 3. They must be bought from the same or immediate seller. And 4. Two or more buyers who are at odds over the rightful ownership of the subject matter must represent conflicting interests. The rules on double sale are found under Article 1544 of the New Civil Code, which says, if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession thereof in good faith, if it should be movable property. Should it be immovable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof to the person who presents the oldest title, provided there is good faith. In case of double sale, the issue of who will be considered as the owner of the property is based on the following rules. If it be movable property, number 1, the first possessor in good faith, and number 2, the buyer who in good faith presents the oldest title. If it is immovable property, number 1, the first person to register the sale in good faith, number 2, the first possessor in good faith, and number 3, the buyer who in good faith presents the oldest title. Article 1544 lays down the rules of preference as to who has superior right over the property in case of a double sale. When the sale involves a personal property, the first possessor in good faith shall be preferred. If it involves a real property, the first registrant in good faith, and if there is nothing to show this fact, then the first possessor in good faith shall follow. And if still cannot be determined, then the person with oldest title in good faith shall be given precedence. With respect to the sale of an immovable, the first registrant in good faith has superior right over the other buyer, and there may be instances where the second buyer is the first registrant in good faith, in which case the second buyer has superior right over the first buyer. However, the registration must be in good faith, meaning the buyer must have no knowledge of the other transaction pertaining to the sale of the same immovable to another buyer prior to or during the registration. Hence, if a claimant purchased the property even when he had full knowledge that it was previously sold to another buyer, even if he registers first, his registration will be in bad faith. Hence, the first buyer will be entitled to prove that he has superior right over the property. In a situation where a party has actual knowledge of the claimant's actual, open, and notorious possession of the disputed property at the time of registration, the actual notice and knowledge are equivalent to registration, because to hold otherwise would be to tolerate fraud, and the torrent system cannot be used to shield fraud. While certificates of title are indefeasible, unassailable, and binding against the whole world, they merely confirm or record title already existing and vested. They cannot be used to protect a usurper from the true owner, nor can they be used for the perpetration of fraud. Neither do they permit one to enrich himself at the expense of others. So this is based on Cagayan Valley Incorporated versus a 2005 case. Concerning the registration of the sale, the Supreme Court, in the case of Oraca versus CA, categorically declared that knowledge gained by the second buyer of the first sale defeats his rights even if he is the first to register, since such knowledge taints his registration with bad faith. This means that the second buyer can no longer rely on the fact that he or she is the first to register the sale, and the first buyer is entitled to prove that he has a better right to the property. Prior registration of the subject property does not by itself confer ownership or a better right over the property. Article 1544 requires that before the second buyer can obtain priority over the first, he must show that he acted in good faith throughout, that is, in ignorance of the first sale and of the first buyer's rights, from the time of acquisition until the title is transferred to him by registration or, failing registration, by delivery of possession. This is based on several cases, including Uraca versus CA and Consolidated Rural Bank versus CA. In the cases of Republic versus CA and Conspecto versus Fuerto, the Supreme Court said, one who purchases real property which is in actual possession of others should at least make some inquiry concerning the rights of those in possession. The actual possession of people other than the vendor should at least put the purchaser upon inquiry. He can scarcely, in the absence of such inquiry, be regarded as a bona fide purchaser as against such possessions. Meanwhile, in other cases, including Caram versus Laureta, Consolidated versus CA, and Spouses Matay versus CA, the Supreme Court said, the rule of caveat emptor requires the purchaser to be aware of the supposed title of the vendor, and one who buys without checking the vendor's title takes all the risks and losses consequent to such failure. Registration of the second buyer under Act 3344, providing for the registration of all instruments on land neither covered by the Spanish mortgage law nor the Torrent system or Act 496, cannot improve the standing of a party since Act 3344 itself expresses that registration thereunder would not prejudice prior rights in good faith. Registration, however, by the first buyer under Act 3344 can have the effect of constructive notice to the second buyer that can defeat his rights as such buyer in good faith. Article 1544 has been held to be inapplicable to execution sales of unregistered land since the purchaser merely steps into the shoes of the debtor and acquires the latter's interest as to the time the property is sold. Sample question. On December 25, 2019, old friends A, B, and C bump into each other while having a good time at El Nido Resort in Palawan. During their friendly conversation, A sold to B a 100 square meter parcel of land located in Pasay City for 10 million, for which A made a partial payment. The sale was evidenced by an informal memorandum written on a table napkin at the resort. Upon his return to Manila the following morning, A sold the same parcel of land to C for 13 million, evidenced by a formal deed of sale which C paid in full and registered in his favor. In the meantime, B had taken possession of the property. Who is the lawful owner of the parcel of land, B or C? That will be all, and thank you. God bless.